My name is Kaya Stanley, and I'm the CEO of CRMBC, California's only restaurant workers' comp self-insured group. And I'm joined here today by Michael Adreani, principal at Roxborough Pomerantz Nye Adreani law firm, where his specialty is on labor and employment, but also workers' comp cost containment. Thank you for joining us today, Michael.
Thank you, Kaya. Nice to be here.
So one of the things that we're doing with this podcast is we're trying to bring extra value to our members, learning about all the different things that they face as restaurant owners, whether it's specifically about workers' comp, specifically about self-insurance, or about restaurant operations. And Michael has generously agreed to come and talk to us about some legal issues that are facing restaurant owners that are kind of confusing to navigate. And this is what you do for a living. And so you see this every day. So you can tell us some of the war stories that you're seeing and some things that restaurant owners can do to protect themselves. Before we dive into the guts of this podcast, will you tell us a little bit about your experience and your practice area and what you're up to?
Sure, especially for this particular topic. My firm is uniquely situated because we specialize in both day-to-day labor and employment law, which would include the class action, the PAGAs, but also more germane to this topic, the individual disability discrimination type cases about discrimination based on having been injured at work. We handle the sexual harassment, the discrimination, pregnancy, all of that on an individual basis, as well as the larger class actions. Now, we also handle cases on behalf of the employers, like restaurants, against their carriers. So we might sue them for posting too much collateral, mishandling the claims, misjudging claims, settling claims that shouldn't be settled. And the same goes for third-party administrators in a self-insured context.
So I'm, as you know, I'm a lawyer also, and I used to practice years ago, but I don't practice anymore. Now I run CRMBC. But in the law, there's something called an exclusive remedy. And when there's an exclusive remedy, typically an injured person has to follow that exclusive remedy. But we see this unique phenomenon in workers' comp where sometimes an employer gets hit with both a work comp claim and a civil claim. And that's what we're going to talk about today. So can you first frame up what the issue is and how is it even possible that they're able to get around this exclusive remedy and file both claims at the same time?
Well, it's an exclusive remedy until it's not, right? So the work comp system in California, like a lot of states, is a no-fault system. This is the great bargain that was reached many years ago, where the state will limit any super exposure to punitive damages and those kind of tortious damages in exchange for what is essentially a no-fault system. It's hard to deny a workers' compensation claim. It happens, but it's difficult. If it happened at work and you were doing something close to work, it's compensable and you get paid for the injury. So what happens sometimes, and I'm seeing it more often, is you have somebody file a work comp claim for the injury itself, and then separate and apart from that, the employee will say, well, because of my injury, I was not given shifts, or I was demoted, or I was not asked to come back when I was healed from my injury. And that is not covered in the workers' compensation laws of the states, not in the labor code. So that kind of discrimination is something that a lot of attorneys have picked up on as a dovetail to essentially file two claims on behalf of an employee. Now, oftentimes I will say it's two different law firms who do this, but sometimes, and there's a phenomenon going on now, it is the same law firm where you have a law firm, believe it or not. I've been to one of these places for a deposition not that long ago, and you walk into their office, and on the left side is the work comp people, and on the right side are the civil people. It's the same law firm, they do both. And it's a problem. It happens a lot nowadays.
Michael, you touched on it a little bit, but can you talk a little bit about the differences so that the audience understands the differences between a work comp claim and a civil claim?
Sure. In a work comp claim, an employee is looking to be compensated for lost time temporary total disability, and the medical costs, just the straight costs of that injury. And, and really the idea is to return somebody to work. Let's fix this. A lot of panel doctors are available. Different kinds of medical treatment are available. And these payments to get you back to work. That's the whole idea of the system. Get you healthy, get you back to work. The civil system is based on damages, not essentially compensation. They're slightly different. The civil system is, look, I'm going to be suffering from this injury for a long time. It affected my relations with my wife or my husband. And by the way, I think the way you treated me was intentional. And I believe the way that you treated me was really discriminatory. You treated me differently because I was limping or because I had this particular medical condition. And a lot of those medical conditions, as you know, and your members certainly know, are not always so obvious. They might be stress claims. They might be mental health claims. And still real. Those can be real claims, but they're not as obvious. And they when they dovetail into a civil claim, it's a little more complicated.
And the damages are obviously completely different. So how, like legally, technically, how do these two play together? When someone hits you with both of these, what do you do as an employer, and how do these two play out together?
Well, I think it's a little bit of two can play that game. That's the way I approach it. And because I'm lucky enough to be somewhat versed in both workers' comp and employment law, the one thing I do when I get a civil case for disability discrimination from a client, from an employer, like one of your members, the very first question I ask is, did they file a comp claim? And if it's a disability discrimination case, the answer is almost always yes. And I want to see that file. I want to know what happened in the comp claim, because usually the comp claim is first. The comp claim will precede the disability discrimination claim because comp claims are so easy to file. And I want to see that file because oftentimes, if you understand the difference between the two systems, oftentimes you'll be able to actually use that to your advantage. So for example, a employee might get injured at work, allegedly, and file a comp claim and say, to maximize, along with their attorney, the value of the comp claim, a lot of the time they'll say, I can't work. I'm unable to work. This injury is so severe and pervasive, and my surgeon says I need a surgery for this or that, and it's going to take me a while. Now, there might be a deposition that says that, something under oath that says that. In the civil claim, a big part of a civil disability discrimination case is, hey, I wanted to work, you just didn't want me there because you don't like people who are hurt. And you discriminated against me, and I could have come back and I could have worked. And we see this all the time. On the one hand, they're saying, I can't work, I'm so hurt, maximizing the value of the comp claim. But on the other hand, they're saying, you should have brought me back because, and if you didn't, it's because you're an evil employer. Those two things are inconsistent. And we look for that, and we find it quite often because, it drives me crazy because in these firms that do both, I don't know what they're thinking. They're literally playing against each other sometimes. So that is one of the dichotomies that I think we always explore. Now, it's not great to have these two different actions going on, but there are ways to play them off of each other. So that's a little bit of good news.
I love it. So I do want to hear some of your war stories, but before that, what can be done to avoid the double dipping?
Well, in a self-insured group like yours, you guys are so much better with your claims and so much more on top of your third-party administrators and your adjusters. They have to do a good job. When you get a comp claim, I think you have to go from the standpoint of assuming, just for yourself, assume that there might be a civil claim in there as well, and deal with the comp claim from that perspective. Get it treated, get it handled right away, get things under oath. Take the deposition if it's at all questionable. Make this person commit I think if they commit to, these are my injuries, this is it, this is how it happened, get the statements, because in a civil case, the incentives are different and they may trip up on that. And if you lock them in, I think they'll be less likely to go the civil route down the line.
This is great advice, obviously, since I do have the ability to impact our TPA for CRMBC, and this is one of the first conversations that we're going to be having. But in addition, for the employer, what advice would you give to the employer?
The employer to stay on top of their TPA for one thing, but I always say policies and practice. I would want them to communicate to employees right off the bat. Come to us immediately with any discrimination claims, with any work comp claims. The work comp posters are very good. And I think people understand that if you're hurt at work, I mean, it's the first question they ask you in the hospital, right? Were you hurt at work? People understand that the comp claims, that procedure. But to the extent that you have any possibility of discrimination, you have to have those same kind of posters up. You have to have that in your handbooks and your manuals and have people understand. If you ever feel any discrimination, whether it's for an injury or disability or an appearance or any kind of sexual or origin type harassment, here's the number. Here's the person you report it to. If you think it's that person, here's another person to report it to. You have to head them off at the pass and say, look, we're here for you for any type of discrimination. Then down the line, if there's a civil suit, you can prove that you knew. You didn't think you were discriminated against until maybe you didn't get what you thought you were going to get from your work comp claim. Come on.
Right.
We see that too.
Right. Do you have any war stories you can share with us?
Well, I think a common theme in some of these war stories is a misconception. And that is that you can settle a workers' comp claim and rid yourself of a civil claim. And I'm sure you guys do a lot of outreach and education on this. That's just not true. And it's not just that you can't settle it. You can't, a lot of times in a compromise and release, you'll see voluntary resignation. Well, that just because, and then you, in the civil case, you say, but you resigned voluntarily. If that was contained in a work comp settlement, it's not entirely valid. Just like you can't release a civil claim in the work comp claim, and vice versa. If you have a civil claim, you absolutely cannot release and protect yourself entirely against the work comp claim. That's actually against the law. So a lot of them have to do with that. So I have a case now where there was a compromise and release in a comp claim for $50,000, and the client thought that did away with the civil claim, and it just doesn't. There's lots of examples of that. So just be careful. Make sure the documentation is there, and that you told every employee if you feel like you're discriminated against because of a disability. Report it and let us know.
Michael, thank you so much for coming on and sharing your expertise on this area. And I know we're going to have you back for many more podcasts, but really appreciate you coming and sharing your knowledge in this area with us today.